and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.com.
Please be seated. The sitting is open. For reasons duly made known to me, Judge Abraham is unable to join us for this afternoon sitting. The court meets this afternoon to hear the United Kingdom, Slovenia, Sudan, Switzerland, Syrian Arab Republic, and Tunisia on the question submitted to it by the United Nations General Assembly. I recall that each of the delegations has 30 minutes for its presentation. This afternoon, the court will observe a short break after the presentation of Sudan. I shall now give the floor to the representative of the United Kingdom, Ms. Sally Langrish. You have the floor, Madam.
Mr. President, members of the Court, it is an honour to appear before you on behalf of the United Kingdom. In participating in these proceedings, the United Kingdom underlines its respect and continued support for the Court. Our position on the Israeli-Palestinian dispute is long established. We firmly believe that a negotiated two-state solution is the only way to end Israel's occupation, to deliver Palestinian self-determination, and to preserve Israel's identity and security. That belief is founded on the relevant Security Council resolutions and the parties' existing agreements. Recent events only reinforce the importance and urgency of implementing the existing framework. On the 7th of October, Israel suffered the worst terrorist attack in its history. Hamas's terrorist attacks and the ensuing conflict in Gaza have resulted in tragic and large-scale loss of life and injury to civilians. Palestinians now face a desperate humanitarian crisis in Gaza. The United Kingdom wants to see an immediate suspension of the fighting in Gaza and then progress towards a sustainable and permanent ceasefire. It is essential to ensure irreversible momentum towards a two-state solution, guaranteeing security, justice and peace for both Palestinians and Israelis. The United Kingdom has only addressed matters of propriety in its written statement rather than the merits of the request. It takes the same approach in these oral submissions. In doing so, the United Kingdom should not be taken to accept any factual allegation or legal proposition advanced by other participants. Over the course of this week, we have heard certain characterizations of Israel's actions which we don't accept. We have also heard characterizations of our own conduct and the motivation for it, which we emphatically reject. We are confident that the Court will find analogies with unrelated cases to be entirely unhelpful. What matters is the case before it today. The United Kingdom confines its submissions to relevant matters of legal principle, firmly founded on the Court's own jurisprudence. We submit that the terms of the request do not allow the Court to give an opinion in a manner consistent with its judicial functions. The United Kingdom will focus today on 3 key points concerning propriety, which will be developed by Professor Saroushi. They are: first, the impact of the non-circumvention principle in this case. Second, the unsuitability of the fact-finding exercise that the Court would have to conduct to answer the request as presently framed. Third, the effect of Security Council Resolutions 242 and 338. Each of these points independently provides a cogent reason for declining to answer the request. The Court will have observed that our third reason has occupied a particularly prominent place in the participants' oral submissions. Should the Court be minded to issue an opinion, then the United Kingdom would respectfully urge it to reformulate the questions to concentrate on the Security Council framework. In this scenario, the Court should focus on assisting the General Assembly in supporting urgent progress towards a negotiated solution. I will address this point in concluding the United Kingdom submissions later. But first, Mr. President, I invite you to give the floor to Professor Saroushi to address the issues of propriety.
Thank you, Ms. Lengrich. I now give the floor to Professor Saroushi. You have the floor, sir.
Mr. President, members of the Court, it is an honour to appear before you on behalf of the United Kingdom. I shall first address the non-circumvention principle. The Court's jurisprudence has long recognised the distinction between its advisory and contentious jurisdictions. The Court has held consistently that its advisory jurisdiction cannot be used to undermine the fundamental requirement of state consent. Further, it should not provide a form of judicial recourse for parties, nor should the Court resolve disputes between parties using its advisory jurisdiction. Instead, the Court's advisory function is to offer legal advice to the UN organs requesting the opinion in order to assist them in their activities. Let me be clear. The United Kingdom does not submit that a state whose rights or duties may be affected by an opinion can prevent the Court from giving an opinion. Rather, consistent with the Court's jurisprudence, the United Kingdom's submission is that where a request is, I quote, directly related to the main point of a dispute between two parties, then the Court should refrain from giving an opinion. In the words of the Court in Western Sahara, to give an opinion in such a case, I quote, would have the effect of circumventing the principle that a court is not obliged to allow its disputes to be submitted to judicial settlement without its consent. Close quote. If the Court were to answer the request as currently formulated, it would entail a breach of the non-circumvention principle. The United Kingdom makes 4 points. The first relates to the nature and content of the bilateral dispute. It is more than a mere difference of views. It is a dispute of acute sensitivity. It is long-standing. It concerns the status of Israel's occupation, issues of security, and the conditions under which Israel can and should withdraw from the occupied Palestinian territories. Second, the request engages that core dispute. The General Assembly asks the Court to consider, in express terms, and rule on both the legal status of the occupied territories and the legal consequences of that status. The Court is also invited to make findings of Israeli responsibility in relation to its policies and practices. This engages key permanent status issues which are at the heart of the Israeli-Palestinian dispute, including on Jerusalem, on settlements, on security arrangements, and on borders. Indeed, a key participant has described the Assembly's request as taking the entire Palestine question to be looked at by the highest court in the globe. The third point concerns the relief requested. The Court is asked to determine that Israel's occupation is unlawful and to order that Israel should withdraw immediately from the occupied territories as a result. Over the course of this hearing, the Court has repeatedly been requested to order Israel's immediate, unconditional and total withdrawal. This repeated insistence further demonstrates that the court is being asked to decide the main point of the dispute, which several states recognise. Finally, Israel has not consented to the main points of the dispute being resolved by this court. To the contrary, it has asked the court to refuse to respond to the request. Given the content of the request as currently formulated, there is thus no basis on which the court should answer it. Participants have identified two main counter-arguments as to why the court should proceed to answer the request. First, they say the court can determine key issues relating to the parties' bilateral dispute because it is of broader concern to the UN. Their argument relies on the court's recognition in the Wall opinion that the General Assembly has a permanent responsibility towards the question of Palestine. The result, they say, is that the request arises, quote, in a much broader frame of reference than a bilateral dispute. With respect, the United Kingdom disagrees. The General Assembly's consideration of a bilateral dispute does not mean that the non-circumvention principle is inapplicable. If it did, the principle would never apply in any advisory proceedings, since any bilateral dispute on which the Assembly made a request would always fall within the so-called broader frame of reference. Such an approach would deprive the non-circumvention principle of all practical application. This approach of the United Kingdom is consistent with the Wall opinion. That opinion did not concern the core aspects of the Israeli-Palestinian dispute. The court itself accepted that it could not properly address what it referred to as the greater whole of the dispute. Judge Higgins characterised that approach as wise and correct. Judge Karoma was careful to distinguish the request in the Wall case from any such broader request that concerned the Israeli-Palestinian conflict as such or its resolution. And Judge Awada accepted that the court's answer should not, quote, be tantamount to adjudicating on the very subject matter of the underlying concrete bilateral dispute that currently undoubtedly exists between Israel and Palestine. A related point that several participants have advanced is that the Israeli-Palestinian dispute is multilateral in character because it concerns erga omnes obligations. The fact that a bilateral dispute may involve obligations in which states have a collective interest does not obviate the need for consent for that dispute to be resolved before the court. Nor does it change the fact that there are two participants involved in that bilateral dispute. The second counter-argument on non-circumvention is that the non-binding nature of advisory opinions means that a court can opine on a bilateral dispute. Like the first argument, this would deprive the non-circumvention principle of all practical application. By definition, Mr. President, all advisory opinions are non-binding, and so the principle would never apply in any advisory proceedings. This ignores that the court is being asked to make findings about Israel's liability and responsibility for various alleged breaches of international law that are central to the bilateral dispute. The court would in substance be deciding on the main points of the dispute if it were to answer the request as formulated. And that is precisely the problem that the non-circumvention principle is intended to avoid. This submission also ignores that serious legal consequences may result from the court's findings. This risk is even more pronounced since several participants asked the court to make legal determinations for the express purpose of clarifying the law relevant to the parties' negotiations. In sum, the principle of non-circumvention is engaged in this case. Mr. President, members of the Court, if this fundamental legal principle is ever to have any real meaning or application, the Court must decline to answer the request as currently formulated. I now turn to the United Kingdom's argument concerning the Court's factual inquiry. Let me be clear. The United Kingdom is not questioning the Court's competence to make factual findings. The Court can, of course, do so, and the United Kingdom does not suggest otherwise. Nor is there any doubt that the information and evidence available to the Court is voluminous. Rather, it is the sheer scale and complexity of the factual determinations that would need to be made by the Court in these advisory proceedings which is the problem. The United Kingdom is not the only participant to raise this issue. Allow me to highlight a few features of the factual determination process in this case. The request in the present case makes no attempt to set out its factual basis. This stands in stark contrast to the Wall opinion. In that case, the request by the General Assembly was based on assumed facts described in a single report by the UN Secretary-General. As one key participant accepts, and as the Court's jurisprudence reflects, this means that it is for the Court, in exercising its judicial function, to independently evaluate the factual materials that have been submitted to it. In this case, the request asks the Court to determine a long list of legal issues and make the necessary factual findings to support them. This is by reference to the entire factual record stretching back some 57 years and the UN dossier spanning nearly 30,000 pages. As a matter of practicality, it is unclear how the Court can properly make the broad range of findings required to answer the request and consider such a volume of material, especially when exercising its advisory jurisdiction, where the Court cannot fall back upon considerations of burden of proof. It is no answer to assume that the Court can defer to the reports of UN bodies. The Court must reach its own independent findings of fact. We emphasise that several states, including the United Kingdom, have expressed reservations about these UN reports. The Court's task is further complicated by a factual landscape that's rapidly shifting in the context of an ongoing and active conflict. This creates the serious risk that the Court may draw legal conclusions on an incorrect factual basis. The problem is further heightened by the gravity of the accusations levelled against Israel, where it is not a party and where the proceedings have been expedited. As this Court has long recognised, quote, claims against the state involving charges of exceptional gravity must be proved by evidence that is fully conclusive. In sum, the United Kingdom submits that there is a serious risk that the Court may undermine its judicial function by giving an advisory opinion in such a context. Mr. President, members of the Court, I now turn to the existing framework, the third point, for resolving the parties' dispute and its impact on these proceedings. The Court is well aware of the agreed framework for a permanent settlement of the parties' disputes as contained in Security Council Resolutions 242 and 338 and in the parties' interim agreements. The precise terms of Resolution 242 are worth recalling. They identify the two interdependent principles of withdrawal and security, to which the Court was referred on Wednesday. To be clear, this resolution does not determine that the occupation is unlawful. The terms of the resolution make this plain. The Security Council and the General Assembly continue to endorse this framework. Most recently, in December 2023, the Council affirmed its unwavering commitment to a two-state solution. Both organs also continue to recognise that a permanent settlement requires a negotiated solution under the auspices of the UN. Many states in these proceedings have emphasised the need for a negotiated solution and the importance of preserving the agreed framework in the context of these proceedings. The United Kingdom shares these views. The parties' agreed framework provides a further basis for declining to answer the request. That framework envisages the negotiation of Israel's withdrawal, not a court decision requiring it. In response to this submission, three main points have been raised by other participants. First, it is said the negotiation process has been stalled for some time. This does not negate the validity of the Security Council framework, nor does it change the reality that a negotiated solution under the UN's auspices is the only possible way in which the conflict will be resolved. It underscores the need to strengthen that process rather than undermine it. Second, some participants have referred to the court's jurisprudence on whether it should take account of adverse political consequences when considering propriety. The court's jurisprudence requires there to be an objective basis to assess the relevance of such consequences. In this case, there is an objective basis. It is the established Security Council framework. The General Assembly's general mandate in respect of the Palestinian question cannot override the Security Council framework. Third, it is argued that an opinion will not interfere with the Security Council framework or with negotiations conducted under its auspices. Instead, it is claimed an opinion will assist that process. Participants rely on the court's statement in the Wall opinion that the negotiations must be conducted in accordance with international law and equivalent language in Council resolutions. And so the court's legal conclusions can and should, they say, constrain the bases on which those negotiations are conducted. With respect, Mr. President, this argument is flawed. It would undermine the very premise of the Council's framework if the court were to address the status of the occupation and require Israel's withdrawal. As I observed earlier, that framework inextricably links withdrawal with security and applies on a reciprocal basis. An unconditional order directed at only one party contradicts that fundamental requirement. It also undermines the additional premise that Israeli withdrawal will be achieved by negotiation rather than by court opinion. Furthermore, an opinion addressing the parties' obligations would prejudice their negotiating positions and thus contravene the court's injunction in the interpretation of peace treaties and the Western Sahara advisory opinions. That, I quote, the legal position of the parties to a dispute cannot be in any way compromised by the answers that the court may give to the questions put to it. For these reasons, the United Kingdom respectfully requests the court to decline the request as presently formulated. Mr. President, I now invite you please to give the floor back to Ms. Langrish.
I thank Professor Saroushi. I now give the floor back to Mrs. Langrish. You have the floor, Madam.
Thank you, Mr. President, members of the court. So Professor Saroushi has explained why the court should decline to answer the request. But if the court is nonetheless minded to provide an opinion, the United Kingdom proposes an alternative course, which seeks to respect the existing framework and ensure the parties' compliance with it. We foreshadowed this approach in our written statement. It is firmly rooted in the court's jurisprudence. Let me start by recalling the court's recognition in the Wall opinion that the resolution of the dispute requires the implementation of Security Council resolutions, in particular resolutions 242 and 338. This, in turn, requires a negotiated solution to the outstanding problems and the establishment of a Palestinian state existing side by side with Israel. Judge Higgins was even more prescriptive. She rightly observed that the resolutions embody key underlying requirements for the resolution of the Israeli-Palestinian dispute, namely that Israel is entitled to exist, to be recognised, and to security, and the Palestinian people are entitled to their territory, to exercise self-determination and to have their own state. Judge Higgins further recalled that Resolution 1515 of 2003 envisages that these long-standing obligations are to be secured both generally and as to their detail by negotiation. Her view was that the court, and I quote, should have used the latitude available to it in an advisory opinion. And she reminded both parties not only of their substantive obligations under international law, but also of the procedural obligation to move forward simultaneously. The United Kingdom's position on the principles for the implementation of Resolutions 242 and 338 has long been clear. First, there must be an agreement on the borders of the two states based on the June 1967 lines with equivalent land swaps between the parties. Second, security arrangements for the Palestinians must respect their sovereignty, and for Israel, they must protect its security. Third, a just, fair, agreed and realistic solution to the refugee question must be put in place. And fourth, the aspirations of both parties for Jerusalem must be fulfilled through negotiations on the status of Jerusalem as the future capital of both states. The United Kingdom agrees with those states that urge the court not to cause prejudice to the existing Security Council framework or to decide any aspect of the parties' bilateral dispute. Like other participants, the United Kingdom recognises that an alternative route to respect propriety is to reinterpret the request or reformulate its terms. There is no question that the court has the power to proceed in this way. It has often been required to interpret or even reformulate the questions put. As Judge Tomka has acknowledged, the court can avoid intruding on a bilateral dispute by narrowing the scope of its answer. The question for the court is how best to achieve these aims. We propose that the court's opinion should focus on endorsing the continued application of the agreed framework with a view to ensuring its urgent implementation. An answer of this kind would respect the three propriety limitations that we have identified. It would also assist the General Assembly to discharge its mandate on the Palestinian question, which many participants have emphasised is the object of this request. More specifically, the United Kingdom, in this alternative submission, respectfully invites the court to do the following: to endorse the continued application of the Security Council framework to both parties and the need for its urgent implementation at the earliest possible opportunity, to recall both parties' obligations to respect the terms of the Council's framework, to recall both parties' agreement not to aggravate their dispute by taking any step to change the status or integrity of the occupied territories until a negotiated solution is agreed. And lastly, to reaffirm the parties' obligations in their interim agreements that they negotiate on permanent status issues. In this way, the court could assist the General Assembly in achieving its stated objective, which is to support urgent progress towards a negotiated solution within the Security Council framework. The United Kingdom reiterates that a negotiated two-state solution is the only way in which the Israeli-Palestinian conflict will be resolved. Mr. President, honourable members of the court, thank you for your attention. That concludes the United Kingdom's submissions.
I thank the delegation of the United Kingdom for its presentation. I invite the next participating delegation, Slovenia, to address the court, and I call Mr. Helmut Hartmann to the podium.
Mr. President, members of the court, it is an honor to appear before you and to do so as a co-agent of the Republic of Slovenia. In the name of the Republic, I wish to extend our congratulations to new members of the Court and to you, Mr. President and Madam Vice President, for your elections. Slovenia has the highest respect for this Court and its important mission to ensure respect for international law on which it is the organ. By its Resolution 77-247 of 30 December 2022, the General Assembly has submitted to the scrutiny of the Court legal questions of fundamental importance for the United Nations and for the international community as a whole. The Republic of Slovenia supported the resolution and the request for an advisory opinion. We are convinced that the advisory opinion of the principal judicial organ will assist the General Assembly and all organs of the United Nations in their efforts and activities concerning the situation in Palestine. As it has been reiterated repeatedly, the United Nations has a permanent responsibility towards the question of Palestine until the question is resolved in all its aspects in a satisfactory manner in accordance with international legitimacy. In its declaration of the current situation in Palestine and Israel, adopted on 23 November last year, the National Assembly of the Republic of Slovenia expressed its hope that the international community, including the United Nations, adopts a more ambitious, responsible and coordinated approach that will constructively support the Middle East peace process, leading to a lasting, peaceful coexistence between two peoples and to a two-state solution. Mr. President, it's hardly need to recall in this great hall of justice that one of the purposes of the United Nations is to bring about by peaceful means and in conformity with the principles of justice and international law, adjustment or settlements of international disputes or situations which might lead to a breach of the peace. International law and its respect constitute the cornerstone of the activities of the organization and of the relations between its member states. As the principal judicial organ of the United Nations, this court's role is to identify existing principles and rules, interpret them and apply them, thus offering a reply to the question arising by the organs of the organization based on law. The questions submitted to your scrutiny concerning the legal consequences arising from policies and practices of Israel are scarcely susceptible of a reply otherwise than on the basis of law. The legal principles and rules upon which the Court is asked to provide an advisory opinion constitute some of the most basic foundations for a peaceful, just, lasting and comprehensive solution to the question of Palestine. The Republic of Slovenia is fully committed to these fundamental principles, ensuring a consolidated multilateral system based on an effective United Nations organization, the sovereign equality of states, collective security, the peaceful settlement of disputes, the self-determination of peoples, high human rights standards, and a powerful rule of international law. We are mindful that a comprehensive solution needs to be achieved through meaningful negotiations aimed at the complete end of the occupation of the Palestinian territory and a resolution of all status issues. It is deeply concerning that despite the efforts of the United Nations and the numerous resolutions of the General Assembly and the Security Council, negotiations have been stalled. As we speak, the prospect of the mutual agreed solution seems to be more and more uncertain. The situation in the region is alarming. Therefore, more than ever, it is indispensable for the organization and for the international community to take and to encourage all efforts that, with a view to achieving as soon as possible, on the basis of international law, a negotiated solution to the outstanding problems and the establishment of the Palestinian state existing side by side with Israel and its other neighbors, with peace and security for all in the region, as the Court emphasized in its 2004 advisory opinion. The Republic of Slovenia, through the voice of its National Assembly, reaffirmed its unwavering support for a negotiated two-state solution on the basis of the 1967 borders, resulting in two sovereign democratic states living together in peace and security in full respect of international law. However, Mr. President, the need for negotiations aimed at the mutual agreeable solution or the existence of the framework for such negotiations are not compelling reasons that should lead the Court to decline the request for an advisory opinion. On the contrary, further clarifications in respect of relevant legal principles, rules and responsibilities can only contribute to a solution on the basis of meaningful negotiations, international law and the rule of law. The Court recalled in 1996 and 2004 that it is, and I quote, aware that no matter what might be its conclusion in any opinion it might give, they would have relevance for the continuing debate on the matter in the General Assembly and would present an additional element in the negotiations on the matter. End of quotation. In this regard, the questions asked by the General Assembly are relevant and have a practical effect guiding the United Nations, its member states, and those most directly involved in respect of the legal implications that need to be taken into account for achieving a lasting, comprehensive and just solution through peaceful means, and particularly through negotiations, is plenty part of the Court's judicial function. As a court of law, as a world court, you are entitled to pronounce on legal questions that will and must drive, frame and facilitate further actions and negotiations aimed at a full and complete settlement of the questions of Palestine. Mr. President, the Republic of Slovenia considers that nothing prevents the Court to address the request of the General Assembly in law and in fact. As I have already recalled, the questions are legal ones. The Court is asked to opine upon the legal consequences arising from policies and practices of Israel. It is thus for the Court to assess whether these policies and practices are in breach of rules and principles of international law, and on this basis clarify the legal consequences of these violations. Moreover, the record before the Court and the information publicly available contains sufficient information and evidence enabling the Court of properly assessing the questions of fact that are relevant and necessary for answering the legal questions before it. Mr. President, members of the Court, I thank you for your attention. Mr. President, may I kindly ask to give the floor to Dr. Daniel, who will continue the presentation of the Republic of Slovenia.
I thank Mr. Hartmann.
So I now invite Dr. Daniel Müller to the podium. You have the floor, sir. Yes, thanks very much. Mr. President, distinguished members of the Court, it's a great privilege for me to appear before you and to do so to assist the Republic of Slovenia. Given the time at my disposal, it's scarcely conceivable to respond to all the aspects of the two questions addressed by the General Assembly in its Resolution 77247, so I'm going to stick to 2 points. First, the relevant rules and principles of international law to respond to the questions posed, and inter alia those relating to the right of the Palestinian people to self-determination. Then, secondly, I'll look at the legal consequences arising from the violations of these rules and principles of international law inter alia for Israel, but perhaps all for all the other states and for the United Nations. I'll do with these 2 points seriatim. Mr. President, the right of the Palestinian people of self-determination, specifically mentioned in the first question posed by the General Assembly, is not open to dispute. Your court has already underscored in your advisory opinion of 2004 that the existence of a Palestinian people is no longer an issue, and that among the legitimate rights of the Palestinian people is that of self-determination. A people's right to self-determination is not just some random right. Indeed, as of 1945, the importance of this right has justified its inclusion in the Charter among the objectives of the organisation and side by side with the principle of the equal rights of peoples. The General Assembly subsequently confirmed in 1960 that, I quote, all peoples have the right to self-determination and that the subjection of peoples to alien subjugation, domination and exploitation constitutes a denial of fundamental human rights, is contrary to the Charter of the United Nations, and is an impediment to the promotion of world peace and cooperation. The 2 covenants that Israel signed as of 1966 and to which it's a party since 1992 also reaffirm that all peoples have the right of self-determination and thus may freely determine their political status and freely pursue their economic, social and cultural development. So the right of peoples, of all peoples, to self-determination is not only one of the essential principles of contemporary international law, it is also a fundamental human right having a broad scope of application. Your court has recognized that the obligations arising from this essential right are erga omnes obligations. Now, as the co-agent has recalled, the Republic of Slovenia is particularly committed to this right. The people of Slovenia were able to exercise it in circumstances which the court will know well, in order to freely establish its own sovereign and independent state. Given its history, the Republic of Slovenia is persuaded that the right to self-determination is an essential and indispensable pillar of the international legal order. More recently, Slovenia has supported the incorporation by the International Law Commission of a non-exhaustive list of peremptory norms in its draft conclusions of 2022, and this list includes, as you well know, the right to self-determination. Now, to this day, the Palestinian people has been unable to fully exercise its inalienable right to self-determination. Indeed, Israel, the occupying power for many decades, is actively preventing the full realization of the Palestinians' right to self-determination in compliance with the guarantees and principles of international law. The occupation of Palestinian territory, its colonization and its fragmentation constitute not only a flagrant violation of the prohibition of the acquisition of territory by force, but also is a considerable impediment to the realization of a free and independent Palestinian state. The court recalled quite rightly that the peoples of non-self-governing territories are entitled to exercise their right to self-determination in relation to their territory as a whole, the integrity of which must be respected by the administering power. As a consequence thereof, any modification of the territorial base to which a people is entitled by right of self-determination, as well as the de facto and de jure annexation by Israel of a considerable part of Palestinian territory, are by their very nature contrary to international law. The need for respect and preservation of the territorial unity, contiguity and integrity of all of the occupied Palestinian territory, including East Jerusalem, recalled once again by the General Assembly in December last year, constitutes an essential condition for the Palestinian people to fully realise its right to self-determination and exercise its sovereignty over its territory. Thus, as the Council for Human Rights has recalled, the Israeli settlements fragmenting the West Bank, including East Jerusalem, into isolated geographical units, severely undermines the exercise of Palestinian self-determination. Mr. President, the right of the Palestinian people to self-determination is fundamentally hobbled by the prolonged occupation of Palestinian territory by the occupying power, and by the non-compliance with the obligations incumbent upon that power under the elementary rules of international humanitarian law. Palestinian territory remains under occupation within the meaning of international humanitarian law. The Court established in its advisory opinion of 2004 that on account of this de facto situation, the relevant customary and conventional rules of international humanitarian law are applicable in occupied Palestinian territory, including East Jerusalem. So, international occupation law is based on the idea that occupation may only be a temporary and provisional situation. The occupying power does not acquire sovereignty over the territory it occupies and must administer it, taking due account of its specific legal status. It must abstain from taking measures likely to entail permanent change, be they the extent of the territory occupied or to its social, economic and demographic reality. More generally, the occupying power must not exercise its authority in order to promote its own interests, or with the aim of using the inhabitants, their property, or the resources of the occupied territory for its own benefit. The occupying power must ensure the protection of the population subject to occupation and take the necessary measures in order to respect their rights and ensure their implementation. Above all, that includes the fundamental rights guaranteeing dignity, equality, and the value of the individual. Rightly, the Court confirmed in 2004 that the treaty instruments relative to human rights remained applicable in OPT, and thus must be respected vis-à-vis the men, women, and children of Palestine. The practices and policies implemented by the occupying power in occupied Palestinian territory do not comply with the elementary obligations of international human rights law or international humanitarian law. The Court already confirmed this in 2004 with respect to the construction of the wall. However, the colonization of occupied Palestinian territory, including East Jerusalem, and the installation of settlements with the aim of achieving lasting demographic change, and the displacement of Palestinians, the destruction of their houses and their property, have but accelerated. The Court, the General Assembly, and the Security Council have recalled that settlements in occupied Palestinian territory have no legal basis and remain illegal. The Council vigorously regretted for a long time the continuation and persistence of Israel in pursuing those policies and practices. The written and oral statements of participants in the instant advisory proceedings have also demonstrated that the practices and policies of the occupying power are not consistent with what is required of it under international law. All these violations of international law arising from the prolonged occupation compromises the effective exercise by the Palestinian people for its right to self-determination and the achievement of a two-state solution, to which the Republic of Slovenia remains profoundly committed. Distinguished members of the Court, Every internationally wrongful act of a state entails the international responsibility of that state. That key provision of the Articles on State Responsibility for Internationally Wrongful Acts contains in itself a part, an important part indeed, of the answer to the question of the legal consequences of the policies and practices which are before you. Israel has engaged its international responsibility. The content of the international responsibility of the State of Israel, or to use the terms of the ILC, the legal consequences involved by this responsibility, are enumerated in Articles 29 through 32 of the Articles on State Responsibility. Israel has the obligation to put an end to its internationally wrongful acts and to all the practices preventing the Palestinian people from fully exercising its right to self-determination. First and foremost of which are the prolonged occupation and annexation of Palestinian territory. Israel must fully carry out its international obligations, in particular its obligation to respect and promote the self-determination of the Palestinian people in the full compliance with international law. The harm caused by these internationally wrongful acts must be fully repaired. Implementation and compliance with these applications arising from the wrongful acts are not only due to Palestine and to the Palestinian people. On account of the erga omnes nature of the rules and obligations breached, which rules are due to the international community as a whole, any state, without distinction, is entitled to invoke Israel's responsibility. Any state can require the cessation of violations and compliance with the obligations in question. Any state is entitled to require the implementation of the obligation of reparation in the interest of the Palestinian people and the state of Palestine. As the court recalled in the Barcelona Traction case, in view of the importance of the rights involved, all states can be held to have a legal interest in their protection. Mr. President, as far as states other than Israel are concerned, and doubtless the United Nations too as an international organization, this isn't merely about summoning Israel to cease its wrongful acts. States do not only have a legally protected interest that Israel respects the right of the Palestinian people to self-determination. All states also have the duty, and the duty is to promote, through joint and separate action, realization of the principle of equal rights and self-determination of peoples in accordance with the provisions of the Charter, and to render assistance to the United Nations in carrying out the responsibilities entrusted to it by the Charter regarding the implementation of the principle. And that is rehearsing, you will have noted, the terms of Resolution 2625 of the General Assembly. In the same fashion, under the terms of Article 1, which is shared in all the 4 Geneva Conventions, the contracting states not only committed to respect the obligations arising from these treaties, but also to ensure respect of these obligations in all circumstances. The practices and policies impeding the realization of the right to self-determination of the Palestinian people cannot exempt the other states and the United Nations from these obligations. On the contrary, in the presence of the illegality of these practices and policies noted time and again by the principal organs of the United Nations, including your court, we must be able to count on the members of the United Nations to draw all attendant consequences and to implement the obligations falling to them pursuant to the Charter and international law. So that would imply for all states and for the United Nations to take the necessary measures to put an end to the tragic and above all illegal situation facing the Palestinian people, and which has faced them over decades. The General Assembly has recalled time and again, and has urged all states and the specialized agencies and organizations of the UN system to continue to support and assist the Palestinian people in the early realization of their right to self-determination, independence and freedom. Furthermore, on account of the nature of the obligations in issue and their importance, states are not only held to cooperate to bring an end through lawful means these serious breaches, they are also under the obligation to not recognize the situation created by these breaches and must abstain from rendering any aid or assistance in maintaining this situation. The Court has already confirmed the relevance and existence of legal consequences for all states in its 2004 advisory opinion, and the General Assembly has requested all states members of the United Nations to comply with their legal obligations as mentioned in the advisory opinion, including those consistent with their obligations under international law and the relevant resolutions not to recognize and not to render aid or assistance in maintaining the situation created by measures that are illegal under international law, and to not aid them in this end. In order to comply with these obligations, all states must inter alia distinguish in their relevant dealings between the territory of the State of Israel and the territories occupied since 1967. As the Security Council recalled in its Resolution 2334 of 2016, referring all the while to your advisory opinion. Mr. President, distinguished members of the Court, the painting by Paul Albert Besnard, which hangs in this great hall, recalls the cardinal principle of contemporary legal order: peace by justice. The Republic of Slovenia is firmly convinced that the scrupulous respect of international law, where the court is the principal judicial organ, can put an end to the unbearable and unacceptable situation in the region and work for a just and lasting peace in which every state in the area can live in security. Mr. President, these words close the oral presentation of the Republic of Slovenia, and on behalf of our delegation, I would like to thank you for your kind attention.
I thank the delegation of Slovenia for its presentation. I invite the next participating delegation, Sudan, to make its oral statement before the court and call upon Mr. Marwan Khair to take the floor.
Mr. President, distinguished members of the Court, it's my honor and privilege to address the International Court of Justice on behalf of the Republic of the Sudan. I express gratitude to this Court for extending the opportunity for my country's participation in these advisory proceedings on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. The Sudan is present here today, owing to the profound significance of these proceedings in the context of realizing the inalienable right of the Palestinian people to self-determination. This matter has persisted on the United Nations agenda for several decades. The dire circumstances prevailing in the occupied Palestinian territory over the past decades, compounded by the current severe humanitarian crisis in Gaza Strip, underscore the profound jeopardy facing the fundamental rights of all people in the Middle East, particularly the Palestinians. Therefore, these oral proceedings assume critical importance in persuading the court to exercise its jurisdiction and accept this request for an advisory opinion. The Sudan contends that such a stand by the principal judicial organ of the United Nations would convey a definitive message to both Israel and Palestine, urging them to redouble their efforts in achieving peace and security for the mutual benefit for their peoples. Moreover, the Sudan maintained the perspective that, in giving this advisory opinion, the court would assume a crucial role in fostering justice, peace, and security, not only in Israel and Palestine, but also in the Middle East and beyond. Mr. President, in accordance with the rules of court, we will address the statement specifically to the issue that, from the perspective of the Sudan, remains a point of contention among the participants in these proceedings, whether or not the court should give the requested advisory opinion. The statement will be as succinct as possible within the limits of what is necessary for adequate presentation of the Sudan's contention at this hearing. Mr. President, I respectfully invite you to give the floor to Professor Raimondo, who will proceed with the delivery of this oral statement. Thank you, Mr. President. Thank you, members of the court.
I thank Mr. Khair. I now give the floor to Mr. Fabian Raimondo. You have the floor, sir.
Mr. President, distinguished members of the court, it is my privilege and pleasure to stand before the International Court of Justice today to address the issues of jurisdiction and admissibility of this request for an advisory opinion. The articulation of objections to the admissibility of a request for an advisory opinion from the General Assembly is not an uncommon occurrence in proceedings before this court. Nevertheless, the court has consistently dismissed such objections. In the subsequent discussion, I shall initially recall the consistent jurisprudence of this court on the issues of jurisdiction and admissibility. It is within this body of jurisprudence that the court can find the resolution to the objections raised concerning the admissibility of the current request for an advisory opinion. As pointed out by this court in the HAGUE's advisory opinion, I quote, "When the court is seized of a request for an advisory opinion, it must first consider whether it has jurisdiction to give the opinion requested, and, if so, whether there is any reason why the court should, in the exercise of its discretion, decline to answer the request." Unquote. The jurisdiction of this court to provide an advisory opinion stems from Article 65, paragraph 1 of its statute. This article provides that the court may give an advisory opinion on any legal question upon the request of any body authorized by or in accordance with the Charter of the United Nations to make such a request. The General Assembly has the authority to request an advisory opinion according to Article 96, Paragraph 1 of the Charter of the United Nations, and this article stipulates that the General Assembly has the power to ask the International Court of Justice to provide an advisory opinion on any legal question. In these proceedings, the Court is first asked to determine the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem, and from its adoption of related discriminatory legislation and measures. Next, the Court is asked how said policies and practices affect the legal status of the occupation and what legal consequences ensue for all states and the United Nations from this status. Mr. President, members of the Court, it is evident that these questions concern the legal consequences of violations of international law that have been recognized as such by the Security Council and the General Assembly, among other United Nations organs and bodies, as well as to the legal status of the occupation in view of those violations and the legal consequences of its illegality. The General Assembly requests the Court to answer these questions in accordance with, inter alia, the rules and principles of international law, international humanitarian law, and international human rights law. For these reasons, the Sudan believes that the request has been made in accordance with the Charter and that the questions submitted to the Court are legal in character. I shall now proceed to the issue of the admissibility of the request. As recalled by the Court in the Chagos advisory opinion, I quote, "The fact that the Court has jurisdiction does not mean, however, that it is obliged to exercise it," unquote. According to consistent jurisprudence of this Court, the discretion whether or not to respond to a request for an advisory opinion exists to safeguard the judicial function of the Court as the principal judicial organ of the United Nations. However, the Court is aware that its reply to a request, I quote, represents its participation in the organization and, in principle, should not be reviewed, end of quote. It is an established jurisprudential principle that this court may decline to respond to a request for an advisory opinion falling within its jurisdiction only in the presence of compelling reasons. The pertinent query at hand is whether there exists any compelling reason for this court to decline to respond to the request referred by the General Assembly. Some participants in these proceedings have indeed alleged the existence of such reasons. The grounds most frequently invoked in these proceedings include, firstly, the contention that providing the opinion would prejudice the negotiation process between the parties involved in the underlying dispute. Secondly, the argument that admitting the request will be incompatible with the principle of consent in judicial settlement. And thirdly, the alleged prejudicial nature of the underlying questions and the lack of sufficient factual inquiry. I will now examine the first ground. This ground was raised by Canada, Hungary, Israel, Italy, and Zambia, among others. Thus, for example, in the opinion of Italy, I quote, "An advisory opinion by the court might reduce the flexibility of the parties in dealing with present circumstances and long-term prospects, and therefore would not contribute to move the process closer to a mutually agreed solution." End of quote. This constitutes a type of argument that this court has previously considered in other advisory proceedings. For example, in the nuclear weapons advisory opinion, the court noted that concerns were raised about the potential negative impact of its response on disarmament negotiations. The court acknowledged that regardless of its conclusions, they would introduce an additional aspect to the negotiations. However, the court stated that the ultimate effect of its opinion is a matter of appreciation and cannot be seen as a compelling reason to refuse exercising its jurisdiction. This jurisprudential principle was confirmed by this court in the advisory opinion on the wall. There is an additional, pivotal aspect to address in this context. The two questions central to the ongoing advisory proceedings pertain to the existing conditions in the occupied Palestinian territory. The court is not tasked with determining the content of a final settlement or the precise boundaries of the Palestinian state. Essentially, the request seeks the court to provide an authoritative legal opinion on the current legal ramifications of the practices and policies of Israel referred to in the request. The advisory opinion is expected to bear relevance to extant queries regarding legal status and its associated consequences. Such clarification holds the potential to significantly contribute to establishing the groundwork for a prospective negotiated resolution of the underlying conflict, rather than to endanger the established framework for negotiations that have been suspended for several years now. Hence, the Sudan believes that this does not constitute a compelling reason to decline responding to the request. I shall now address the second ground, the contention that the opinion would circumvent the principle of consent in judicial settlement. This ground was raised by Canada, Fiji, Hungary, Israel, and the United Kingdom, among other participants. For example, Canada objects that, I quote, "It is Canada's understanding that Israel, which has a direct interest in this case, has not provided consent for the ICJ to desist of this matter." End of quote. It is well-established jurisprudence of this court that the lack of consent to the court's contentious jurisdiction by interested states does not impact the court's jurisdiction to render an advisory opinion. This rationale is exemplified by instances such as when the court gave its advisory opinion on Western Sahara, even in the absence of Spain's consent to the request. When it delivered the advisory opinion on the wall, despite Israel not providing consent. And when it issued the Chagos advisory opinion, notwithstanding the absence of consent from the United Kingdom. In each of these instances, the court gave its opinions, even though the request concerned the responsibility of particular states. As this court said in Western Sahara, I quote, "In the present case, Spain is a member of the United Nations and has accepted the provisions of the Charter and Statute. It has thereby, in general, given its consent to the exercise by the court of its advisory jurisdiction." Unquote. In the Sudan's view, the same rationale applies in the current advisory proceedings. The General Assembly has consistently played a crucial role in matters concerning Palestine, as evident from the documentation presented in the Secretary General's dossier before this court. The Palestinian people are yet to realize the right to self-determination, a fact that no state can plausibly contest. Therefore, the Sudan believes that the objection to the General Assembly's exercise of its competence in the realm of self-determination and its consideration of the situation in Palestine is unpersuasive. I shall now address the final ground, the allegedly prejudicial nature of the questions posed by the General Assembly and a lack of appropriate factual inquiry. This ground was raised by Israel in the following terms, I quote, "The tendentious questions placed before the court not only distort the factual reality, they fundamentally misrepresent the legal reality as well." End of quote. In the same vein, another participant in the proceedings, the United Kingdom, posits that the request is inadmissible on the ground that, I quote, "the court cannot be confident that it will have a complete or accurate evidential picture before it. End of quote. Further, in this regard, the United Kingdom contends that, I quote again, insofar as Israel does not participate in the advisory proceedings by furnishing evidence relevant to the request, the court will lack material explaining the Israeli side of the picture. End of quote. Nevertheless, it is imperative to recall that in the overwhelming majority, if not all, of the opinions rendered by this court, reliance on public information derived, for instance, from United Nations organs or specialized agencies has been a standard practice. In part 2 of the dossier of materials before this court, there are many reports of competent United Nations bodies, such as the Special Rapporteur on the Situation of Human Rights in the OPT, the High Commissioner for Human Rights, and several human rights treaty bodies. Hence, in the Sudan's view, all these reports provide the court with sufficient information on the facts before it to give the requested opinion. Mr. President, members of the court, I express my gratitude for your attentive consideration, and I respectfully invite you to request Mr. Hare to deliver the concluding remarks of the oral statement on behalf of the Sudan.
I thank Mr. Raimondo. I now give the floor back to Mr. Khair. You have the floor, sir.
Mr. President, distinguished members of the court, I wish to emphasize the great significance of the right of peoples to self-determination. In advisory proceedings conducted before this court, wherein the exercise of this right was a pivotal concern, the court's opinion emerged out of fundamental elements shaping the legal framework for resolving the underlying disputes, such as the one concerning Namibia. If only we had a comparable equivalent for Palestine. The successful resolution of the protracted dispute surrendering Namibia can be largely attributed to the court's judicial task. It's respectfully suggested that you should persist in fulfilling that role in the present advisory proceedings. In the light of the foregoing, the Sudan concludes that the court not only has jurisdiction to give the advisory opinion requested by the General Assembly, but also that there is no compelling reason for this court to use its discretionary power not to give the opinion. Thank you, Mr. President. Thank you, members of the court.
I thank the delegation of Sudan for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.
The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv.
Discover the Islam Channel podcast, where you'll find a perfect blend of inspiration, news, and business insights, all rooted in the beauty of our deen. Stay up to date with the latest trends. Engage in thought-provoking discussions. Subscribe to the Islam Channel podcast today. Discover the Islam Channel podcast, where you'll find a perfect blend of inspiration, news, and business insights, all rooted in the beauty of our deen. Stay up to date with the latest trends. Engage in thought-provoking discussions. Subscribe to the Islam Channel podcast today.
The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.
Discover the Islam Channel podcast, where you'll find a perfect blend of inspiration, news, and business insights, all rooted in the beauty of our deen. Stay up to date with the latest trends. Engage in thought-provoking discussions. Subscribe to the Islam Channel podcast today. Discover the Islam Channel podcast, where you'll find a perfect blend of inspiration, news, and business insights, all rooted in the beauty of our deen. Stay up to date with the latest trends. Engage in thought-provoking discussions. Subscribe to the Islam Channel podcast today. Discover the Islam Channel podcast, where you'll find a perfect blend of inspiration, news, and business insights, all rooted in the beauty of our deen. Stay up to date with the latest trends. Engage in thought-provoking discussions. Subscribe to the Islam Channel podcast today.
Please be seated. The sitting is open.
I now invite the next participating delegation, Switzerland, to address the court and call Mr. France Perez to the podium. Sir, you have the floor.
Mr. President, distinguished members of the court, it's an honor for me to appear before you on behalf of the Swiss Confederation. The terrorist attacks perpetrated by Hamas and other armed groups on the 7th of October 2023, firmly condemned by Switzerland, and the ensuing violent confrontation in Gaza are today in all our minds. They contribute to polarizing even further positions within the international community and undermine the prospect of a negotiated two-state solution. This potentially makes the task of the court more arduous, but also more necessary than ever. Our presentation will not concentrate on the terrible events of 7th of October and the situation that flows from it, but on the legal questions as posed to the court on 30th December 2022, which relate to the status of prolonged occupation. Israel has legitimate security concerns, but also the obligation to comply with international law. Similarly, the Palestinian people has the right to self-determination with the aim of living in peace, and Palestine has the obligation to respect international law, and fair and lasting solution can only be achieved on the basis of the rules of international law. A good understanding of the content of the obligations under international law is therefore a precondition for negotiating a solution that reflects the legitimate interests of both parties. Thus, it's therefore essential to better understand the legal questions relating to measures taken within the framework of the prolonged occupation of Palestinian territory. The opportunity for the court to provide an impartial response based on international law to the questions posed by the General Assembly and thereby provide a basis for a negotiated solution therefore remains essential. My oral presentation will focus on the specific issues linked to the prolonged occupation under the angle of international humanitarian law and human rights law. Moreover, I'll refer to our written submission of 17 July 2023 and to the developments contained therein. The law of the occupier and the legality of occupation are two distinct questions. The law of occupation applies independently of the question of the legality of occupation. Occupation is a situation that is governed by international humanitarian and human rights law, whereas the legality of it is governed by the UN Charter. The potentially illegal character of an occupation must not call into question the fundamental separation between jus ad bellum and jus in bello. The right of occupation continues to apply in Palestinian territory, irrespective of the question of the legality of the occupation. As such, the prolonged character of an occupation has no incidence on its conformity with jus in bello. No provision of humanitarian law prohibits prolonged occupation. What's more, prolonged occupation remains governed by humanitarian law, supplemented by human rights law, irrespective of a de facto possible annexation. Nevertheless, occupation is understood as a temporary situation. Occupation that is prolonged may lead to a tension between, on the one hand, the obligation for the occupier to maintain the status quo ante, on the other hand, to ensure the well-being of the occupied population. It is this tension and its legal consequences that I'd like to deepen within the framework of this oral submission. To do this, I'll begin by generally addressing the prolonged occupation and the challenges it poses from the standpoint of humanitarian and human rights law. Next, I'll analyze three concrete areas illustrating this tension: the need to interpret and apply contemporary international law in an evolving and systemic manner to ensure protection and well-being of the population. The concrete areas addressed are firstly the legislative administrative competences of the territory, secondly access to items that are indispensable to the survival of the population and protecting dignified life, and lastly, use of force in occupied territory. Allow me, first of all, to address the legal challenges posed by prolonged occupation. The rules of the law of occupation were not developed to regulate situation of occupations lasting several decades. They're based on four fundamental principles that underscore the necessary temporary nature of occupation and to establish a balance between military and humanitarian necessity. Firstly, the occupier doesn't acquire sovereignty over the territory he occupies. Unilateral measures calling into question the territorial status quo are therefore never admissible. A modification of the status of occupied territories can only be envisaged within the framework of a negotiated solution. Secondly, the occupier must maintain the status quo ante and not take measures that might lead to permanent changes, in particular from the social, economic and demographic standpoint. Thirdly, the occupier must maintain security and public order in the occupied territory and administer it in order to ensure the protection and well-being of protected persons. Fourthly, the occupier must not exercise his authority for the purposes of serving his own interests, that of his territory or his population. Within the framework of a prolonged occupation, tensions might indeed appear between these four principles. For example, the well-being of the civilian population might necessitate changes to the status quo. In this context, there's a need to distinguish clearly unlawful situations that undermine the status quo, such as, for example, settlements, from those where the status quo would in fact be maintained to the detriment of the population of the occupied territory. In this case of a prolonged occupation, it is vital that the maintenance of the status quo should not be understood as a freeze on the situation, but as signifying that the populations of occupied territories must continue to be able to live a normal as life as possible in dignity. Occupied territories must not remain frozen in time, but be able to move with their time. To address the legal tensions and challenges specific to a prolonged occupation, it's important to recall the function and the purpose of humanitarian law are to protect and ensure the well-being of the population and not to justify intrusive measures in the interest of the occupying power. The obligation of the occupying power to ensure the well-being of the occupied population calls for an interpretation in favor of the higher interests of the population living under occupation. In order to resolve the tension between the aforementioned principles and better determine the legality of measures taken by the occupier during a prolonged occupation, I suggest three criteria derived from a combined interpretation of humanitarian and human rights law. Firstly, the adoption of specific measures going a priori against the obligation of maintaining the status quo to serve the interests of the occupier is not admissible except for overriding security reasons, and as long as the well-being of the population is not affected in a disproportionate manner over the long term included. Secondly, specific measures running counter to the obligation to maintain the status quo can be adopted if they benefit the population of the occupied territory, consistent with human dignity, and take account of the wishes of the population in the occupied territory and its historical and cultural specificities. Lastly, thirdly, the adoption of such measures is statutory when these measures amount to parallel obligations of humanitarian and human rights law. If humanitarian law was specifically designed to govern situations of armed conflict, it remains that human rights remain fully applicable in situation of occupation. The Fourth Geneva Convention compels the occupying power to assume active responsibility for the well-being of the population under its control. This obligation to protect the population under occupation and to promote its well-being is concretized in the obligation to respect, to protect, and to fulfill the human rights of the occupied population. The characterization under humanitarian law of lex specialis must therefore not be construed as meaning that this law overrides human rights. In principle, there's no direct contradiction between the obligations arising out of humanitarian law and human rights law. On the contrary, humanitarian and human rights law are mutually reinforcing. Thus, Article 27 of the Fourth Geneva Convention requires that the fundamental rights of protected persons be respected in all circumstances. It proclaims the respect of the human person and the inalienable right of its fundamental rights. In the event of prolonged occupation, the relevance of human rights is all the more significant. The logic of humanitarian law is aimed at immediately ensuring the essential minimum needs of the population. This must be supplemented by the need of ensuring over the long term a dignified life. Thus, the balance between humanitarian and human rights law fluctuate with the prolonged character of an occupation. The longer the occupation is prolonged, the more the respect for and guarantee of human rights are important. To close this part, I'd like to stress that all actors exercising de facto control are also bearers of obligations at Israel's side. The practice of UN organs recognizes that, at minimum, an armed non-state actor exercising the governmental type functions or controls, in fact, a territorial population must uphold and protect the human rights of the inhabitants. Palestine, having notably ratified Covenants 1 and 2 of the UN relating to human rights and the UN Convention against Torture, has the positive obligation to take all measures in its power and compatible with international law to assure to persons living in these parts of its territory the rights guaranteed by the Convention. Israel and Palestine are under obligation to cooperate and support one another and not to weaken one another in their efforts to ensure the well-being of the population. Victims must also be able to seek reparation for violations or abuse of their rights, whoever the actor at the origin of their grievance, in order to ensure effective respect of human rights. These various actors must cooperate by taking into account that the scale of their obligation will vary notably of the control they exercise and the resources available to them. I come now to the concrete areas, starting with that of legislative and administrative competences of the territory. By virtue of the principle of maintaining the status quo, the occupier cannot take measures bringing about permanent changes, in particular the social, economic and demographic standpoint. The occupier must restore and ensure, as far as possible, public order and safety while respecting, unless absolutely prevented, the laws in force in the country. However, by virtue of Article 64, paragraph 2 of the Fourth Geneva Convention, we can deduce that the occupier might introduce new laws if these are indispensable to ensure A, the security of the occupier, B, order of public life, and thirdly, respect for humanitarian law. Though human rights are not in the exceptions of maintaining local law, an updated reading of humanitarian law requires that their respect be guaranteed. Thus, in the case of prolonged occupation, the obligation to ensure public order and safety implies that the occupier administers the territory in such a way as to ensure protection and well-being of protected persons, not only respect and protect, but also provide them with a right to a dignified life. This, of course, means that he has to move away from the status quo. Mr. President, members of the court, the adoption of measures such as planning, zoning, contradicts the previously mentioned criteria. This regime contributes to put in place a coercive environment, aggravating the risk of forced transfer. Aside from the fact that this regime calls into question the territorial and demographic status quo by promoting Israeli settlements, it cannot be justified under security requirements because it excessively affects the well-being of the population and is discriminatory. In the event of prolonged occupation, the occupier is required, on the contrary, to encourage planning and development of the occupied territory as a priority through local authorities and institutions in favour of the local population. This requires, Mr. President, members of the court, a cooperation with local institutions, support and a strengthening of the latter and not their erosion. I will now turn to the second concrete area, that's to say access to vital goods for the survival of the population and protecting a dignified life. Humanitarian requires that the occupier supplies the population with essentials for its survival. The obligation to restore order and public life must be interpreted broadly and designates the various aspects of the life of the population. The occupier is therefore entitled to make changes going a priori against the status quo as long as they're necessary to improving local life. As indicated above, the conditions of existence of the population under occupation are also governed by human rights, which notably, in a context of prolonged occupation, support and reinforce humanitarian law. The occupier must immediately ensure minimum enjoyment of economic, social and cultural rights and refrain from adopting measures that would limit their exercise. Next, with the prolongation of occupation, the obligation to gradual achievement comes into play. It requires the occupier fully assumes the exercise of these rights in time. Furthermore, by virtue of the right to life, the occupier has the obligation to generate conditions of existence in accordance with human dignity for persons living under his jurisdiction. In the face of prolonged occupation, the economic and social development of the territory may require long-term changes which are opposed to maintaining the status quo. This, of course, creates obligations for Israel as occupying power as well as for Palestinian actors. Mr. President, members of the court, these regressive measures and the use of resources on Palestinian and on occupied Palestinian territory, regressive measures and the use of resources of the occupied Palestinian territory for the needs of the occupier clearly run counter to the previously mentioned criteria. They require modifications of the status quo for the interests of the occupier to the detriment of the Palestinian population. Furthermore, the absence of a gradual realization of human rights is an issue of concern. Lastly, third specific area illustrated in the context of prolonged occupation, the tension between the right of the occupier to guarantee his security, the obligation to ensure the well-being of the population by using the example of the use of force in operations to maintain order. Under Article 43 of the Hague regulations, the occupier may use force to restore and ensure, as far as possible, public order and safety. However, such a use of force should not be a matter for the conduct of hostilities. Article 43 is but a referral to rules of maintaining order that form part of human rights and the right to life. Maintaining order rests on three principles: necessity, proportionality, and precaution. By way of the principle of necessity, the use of lethal force can only be used in last resort and must pursue an objective goal, such as self-defense or to defend a third party in the event of imminent threat to life. This imminence criteria is strict and cannot authorize use of force preventively. Furthermore, the use of force must always be individualized. A crowd of demonstrators cannot be considered as such as a threat to life. Furthermore, a differentiated use of force must be used if possible. This requires supplying appropriate equipment and weapons for maintaining order, including water cannons, batons, and rubber bullets. By virtue of the principle of proportionality, the degree of force used must be strictly proportionate to the gravity of the offence and the legitimate goal to be reached. Incidental losses are generally not tolerated, and the life of persons who disrupt order must be taken into consideration when weighing up the interest. By virtue of the precautionary principle, law and order operations must be planned with the goal of avoiding the use of lethal force. All this is removed from a logic specific to the conduct of hostility. In the context of occupation that is prolonged, maintenance of order is applied by default. Hybrid situations of civilian and hostile violence must be far rarer than the context of a nascent occupation. Weapons and equipment made available to occupying or security forces must be similar to those which are used by states in peacetime. The use of combat weapons and the use of snipers is even more inappropriate during long-term occupation. The militarization of maintaining order operations must be avoided ex ante when a legitimate legislative and administrative framework must be put in place to regulate the use of force, and the training of Israeli forces must be consistent with international maintenance of order. Ex post, any use of lethal force must be the subject of an actual investigation to ensure accountability, and in the case of proven violations of human rights, there is a requirement to bring those responsible to justice. Israel, as an occupying power, must protect the civilian Palestinian population in the West Bank. The violence exercised by individuals such as settlers towards the population of the occupied Palestinian territory must also be investigated and, where appropriate, subject to criminal proceedings. The positive obligation to protect the population from third parties is an essential component of the right to life. In conclusion, prolonged occupation may a priori give rise to tensions between maintaining the status quo, security of the occupier, and the well-being of the population. These tensions are resolved by humanitarian law, supplemented by human rights law. The longer the occupation, the more respect and guarantee of human rights are important. The joint application of these two legal regimes strengthens the protection of populations living under occupation and may impose specific measures that run counter to the obligation to maintain the status quo. Thus, the development of the territory requires the adoption of positive measures in favor of the population of the occupied territory. Similarly, the well-being of the population requires transformations aimed at improving its conditions of life. Lastly, in the presence of a prolonged occupation, the use of force is presumed to form part of law and order. All parties must prevent violence and the resurgence of hostility in order to guarantee a life as dignified and as normal as possible to the population. In this spirit, Israel and Palestine must cooperate and support one another mutually and not weaken one another or erode the authority of the other party. Mr. President, members of the court, this brings to an end the written submission of Switzerland. Thank you for your attention.
Je remercie la délégation de la Suisse pour son
I'd like to thank Switzerland for their exposé.
public to address the court and call His Excellency Mr. Ammar Al-Hassan to the podium.
Mr. President, distinguished members of the esteemed court, it is an honor and privilege to address the esteemed court today on behalf of the Syrian Arab Republic at a very sensitive time, while the Palestinian people find themselves with no real protection. In this oral statement, I will present my country's position regarding the questions related to this case in accordance with what was stipulated in the relevant General Assembly resolution. Out of respect for the time allotted to me by the esteemed court, I will get straight into presenting my country's legal position. Mr. President, distinguished members of this honorable court, the theory of occupation in principle contradicts all the values, ethics, laws, and charters that humanity has established throughout its long history. In order to preserve human dignity and sanctity, to maintain international peace and security, and to save the world from the scourges and sufferings of wars. In fact, the crime of occupation has been and continues to be the most serious and heinous crime in the history of mankind, taking into consideration the occupation's flagrant violation of the Charter of the United Nations, the provisions of international law, international human rights law, and international humanitarian law, and all international charters and customary rules. In fact, occupation acts primarily on the basis of usurping land by force, which is essentially prohibited under international law and the provisions of the Charter. It also acts on the basis of suppressing the will of the people, seeking to degrade their dignity and deprive them of their basic rights. Today, the practices of Israel, the occupying power, are definitely the clearest reflection, unfortunately, of the failure of the international community to prevent heinous crime of occupation and to ensure the implementation of the relevant resolutions of Security Council, General Assembly, and the Human Rights Council. The Syrian Arab Republic stresses the need to hold Israel accountable for its grave and continuing violations of the provisions of international law, the Charter of the United Nations and its relevant resolutions, and the provisions of international humanitarian law, including provisions in Section 3 of the Fourth Geneva Convention of 1949, Article 47, and what follows. Mr. President, distinguished members of the Court, we are here today to make sure that they, the occupiers, do not get away with impunity. The first question before the distinguished Court today relates to one of the most important and noble human rights, which is the eternal and fundamental right to self-determination. The right to self-determination is a fundamental human right that is enshrined, among other international instruments and conventions, in Article 1, Paragraph 2 of the Charter of the United Nations, providing that each state shall, and I quote, refrain from any forced action depriving peoples of their right to self-determination, freedom, and independence, end of quote. And that each state shall, again I quote, encourage through joint and unilateral action the realization of the principle of self-determination of peoples, end of quote. This right is also reiterated and affirmed in common Article 1 between the Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights, which obliges states that are parties to these covenants to promote the realization and respect of this right in accordance with the provisions of the Charter of the United Nations. Israel violates this right through, for example, the establishment and continued expansion of illegal settlements in the occupied Palestinian territories, including Jerusalem. We note, in particular, the discriminatory Israeli legislation of 2018, or what is so-called the Basic Law, Israel as the nation-state of Jewish people, which recognizes the right to self-determination exclusively for the Jewish people, denying the right of the Palestinian people to self-determination on their land and in their homeland. I shall now turn to talk about the legal consequences. Israel must be held accountable for its violations of international law and United Nations resolutions. Israel must put an immediate end to the violation of its international obligations by halting all actions and measures that prevent and/or impede the exercise of the Palestinian people's right to self-determination, including putting an immediate end of the occupation in all its forms. For third states, since the right to self-determination is an erga omnes argument and obligation on all subjects of international law, all states must respect it and seek to achieve it. It is also the responsibility of all states, consistent with respect for the United Nations Charter and international law, to immediately put an end to the obstruction of the Palestinian people's exercise of their right to self-determination. The United Nations, in particular the General Assembly and the Security Council, should consider the additional procedures and binding international legitimacy tools stipulated in the Charter that are required to put an immediate end to any obstruction preventing the Palestinian people from obtaining their right to self-determination, and to take the necessary measures in order to ensure the implementation of its relevant resolutions without any further delay. With your permission, Mr. President, I shall delve into the part of the question regarding prolonged occupation, settlement and annexation, along with changing the demographic composition. The illegal Israeli settlements and the system associated with them are based actually on a dual process. On one hand, the forced displacement of Palestinians and the confiscation of their lands, and on the other hand, the transfer of Israeli settlers and the construction and expansion of settlements on confiscated lands. International humanitarian law prohibits the forced displacement of the occupied people and the transfer of citizens of the occupying power to the occupied territories, as confirmed by Article 49 of the Fourth Geneva Convention, that provides for the protection of civilians in the time of war. Thus, forced displacement and transfer of citizens by the occupying power constitute grave violations under Article 147 of the aforementioned Convention. Indeed, the actual annexation of parts of the occupied Palestinian land is embodied through a continuous gradual process involving the implementation of many measures and actions that include, among others, settlements' size, infrastructure, and location, which indicate the purpose to make them sustainable. Israeli government plans and directives that allowed the establishment and expansion of settlements. The legislation that enacted a dual legal system in the occupied territories in favor of the settlers at the expense of the occupied people, including the Basic Law of 2018, aka Israel as the nation state of the Jewish people. Another example, public statements of Israeli officials demonstrate to the fact that the settlement and the system associated with them constitute a deliberate policy of obtaining a permanent presence for the annexation of the territories, and confirm that the actual annexation had already taken place. The guidelines and coalition agreements of the new Israeli occupation authorities, sworn in on the 29th of December 2022, in which they explicitly declare that the Jewish people have an exclusive and indisputable right to all areas of Israel, and undertake to strengthen and develop settlements throughout what they called the land of Israel, in the Galilee, the Negev, the West Bank, and in the occupied Syrian Golan, despite the confirmation by the United Nations Security Council Resolution 497 of 1981 that provides, and I quote, "The Israeli decision to impose its laws, jurisdiction and administration in the occupied Syrian Golan Heights is null and void and without international legal effect." End of quote. Mr. President, distinguished members of the Court, in 1980, the Israeli Knesset adopted the Basic Law on Jerusalem, which states that Jerusalem, whole and united, is the capital of Israel, effectively annexing the city in flagrant violation of international law and of the city's own international status. In response, the United Nations Security Council adopted Resolution number 478, which declared that, again I quote, "all legislative and administrative measures and actions taken by Israel, the occupying power, which have altered or purport to alter the character and status of the holy city of Jerusalem, and in particular the recent Basic Law on Jerusalem, are null and void and must be rescinded forthwith." Mr. President, since then, the Israeli occupation authorities have worked to consolidate further annexation instead of reversing it. I shall now talk about the legal consequences. Israel is obliged to immediately stop all its violations of its legal obligations in Jerusalem and all other occupied Palestinian territories. The cessation of such violations entails, inter alia, the dismantling of illegal structures, including settlements and the apartheid wall, the cancellation or the activation of all legislative and regulatory acts adopted by Israel with the aim of building illegal settlements and normalizing said system. Also, Israel is obliged to make reparation for the damage caused to individuals concerned through restitution and compensation. Regarding the legal consequences for third states, the United Nations General Assembly, in its resolution 77/25, called on all states, inter alia, first, not to recognize any alterations to the pre-1967 borders and to ensure that agreements with Israel do not imply recognition of Israeli sovereignty over the territories occupied by Israel in 1967. Second, not to provide aid or assistance to illegal settlement activities, specifically with settlements in the occupied Arab territories of Palestine and the Golan, in line with Security Council Resolution 465 of 1980. For the United Nations, the international organization, in particular the General Assembly and the Security Council, should consider the additional measures and binding international legitimacy tools stipulated in the Charter that are required to immediately end the illegal occupation and take the necessary measures to ensure the implementation of its relevant resolutions without any further delay. Your Honours, just as a reminder, today we are talking about a huge record of UN resolutions that Israel keeps violating. Actually, when it comes to the Arab-Israeli conflict, we are talking about 180 resolutions of the General Assembly and 227 resolutions of the Security Council. Mr. President, allow me now to move on to the part of the question regarding discriminatory legislations and measures. Since its inception, Israel has adopted various discriminatory legislations aimed to ensuring its control over the maximum geography with the minimum possible number of Palestinians. The United Nations Human Rights Council has described the Israeli discriminatory measures as, and I quote, a combination of movement restrictions consisting of the wall, checkpoints, a permit system that affects only the Palestinian population, and the application of a two-tier legal system that facilitated the establishment and consolidation of settlements and other violations and forms of institutional discrimination. End of quote. The United Nations General Assembly has always, and for many years, condemned in a large number of resolutions the discriminatory policies and practices of Israel, the occupying power, against the Palestinians as well as the Syrians in the occupied Syrian Arab Golan. These policies and practices include, according to these resolutions, killing and injuring civilians, arbitrary arrest and detention, in addition to forced displacement of civilians, transfer of settlers to the occupied Palestinian and Syrian territories, destruction and confiscation of civilian properties, and demolishing homes. Your Honors, in the devastated Gaza Strip, long before the 7th of October 2023, Israel practices racial discrimination towards the Palestinian population in the form of its ongoing blockade. The discriminatory nature of the blockade actually imposed on the Gaza Strip was recognized by the United Nations Committee on the Elimination of Racial Discrimination. This blockade was found to violate the Convention on the Elimination of Racial Discrimination. The actions of Israel are part of a large-scale, repressive, organized and systematic regime. Such actions have been identified as apartheid after thorough factual and legal examination by the UN Special Procedures and by various international organizations. Apartheid is most manifested in the occupied Palestinian territories, including Jerusalem, where illegally located settlers benefit from far-reaching privileges at the expense of the basic rights of the Palestinian people. For legal consequences, Israel is obliged to immediately repeal all legislations aimed at or leading to the maintenance and perpetuation of apartheid and racial discrimination against the Palestinian people. This includes the termination of its settlement activities, the cessation of all discriminatory policies and practices, along with due compensation to all those affected by these policies and practices, including Palestinian refugees. For third states, they must not recognize this illegal situation and must not provide any help or assistance in any way that may sustain and maintain this situation. For the United Nations, especially the General Assembly and the Security Council, the international organization should consider the additional measures required to end the apartheid system established by Israel and should take the necessary measures to ensure the implementation of its relevant resolutions without further delay. After this review, allow me, Mr. President, to present my country's legal position on the second question presented before the distinguished court in accordance with the relevant General Assembly resolution. It's about illegal status of occupation. The acts and practices of occupying powers are strictly regulated by international law and international humanitarian law. Article 49, paragraph 6 of the Fourth Geneva Convention stipulates that, and I quote, "The occupying power shall not deport or transfer parts of its civilian population to the territories it occupies." End of quote. While the occupying power is obliged under international law to administer the territory for the benefit of the people under its occupation, Israel administers the territory only for the benefit of its settlers, and even to ensure the sustainability of the illegal occupation of others' land. While annexations or claims of sovereignty over territories under the interim administrative authorities of the occupying power are strictly prohibited, Israel has sought to exercise fait accompli sovereignty over Jerusalem and the occupied Arab territories. Mr. President, members, distinguished members of this honourable court, we believe in the first place that the Israeli occupation in and of itself should be considered absolutely illegal, and that we should not be satisfied with only and merely describing its practices and policies. Allow me now to move to the legal consequences. The legal consequences constitute Israeli commitment to an immediate and unconditional end to its occupation of the Arab territories in Palestine and the rest of the occupied Arab territories, including the Syrian Arab Golan, in addition to providing compensation to all those affected. For third states, it is imperative to commit to support all efforts exerted to end the illegal occupation without delay, and to refrain from any actions that contribute to maintaining the illegal situation. For the United Nations, in particular the General Assembly and the Security Council, it should consider the additional measures and binding international legitimacy tools stipulated in the Charter that are required to ensure the implementation of the relevant resolutions without any further delay, including the immediate and unconditional end to the Israeli occupation of the occupied Arab territories in Palestine and the Syrian Golan. The Honourable Judges, the Syrian Arab Republic affirms the principle that states shall not obtain legal rights from unilateral acts that do not comply with international law. Syria also re-emphasizes the temporary nature of the occupation, and that even if it is a fait accompli, this does not and will not give the occupying power the right to acquire sovereignty over the occupied territories, no matter how long this brutal occupation lasts. Syria reiterates that the stability of the Middle East and the credibility of the United Nations system, including the esteemed court, require taking measures to ensure the implementation of all relevant international resolutions to end the Israeli occupation of all occupied Arab territories in accordance with the relevant United Nations resolutions. Mr. President, esteemed members of the court today, in this case, does not create new rights, but rather reveals rights that are violated by Israel every day since 1948. Israel is not only committing the horrendous act that we have just mentioned, but we are currently witnessing Israel committing genocide in the occupied Gaza Strip, attacking Syria, attacking Lebanon, and committing war crimes and crimes against humanity. In fact, one of the reasons for Israel's consideration of itself as being above the law is that it has been carrying out illegal occupation and committing crimes for 75 years without facing accountability or any sort of consequences. Today, it has become imperative for all states to convince or to show Israel, the occupying power, by all possible legal means that it does not have a green light to annex more occupied territories, expel their indigenous people, and build more illegal settlements. Most importantly, convincing and showing Israel that there will be no peace, no security or stability for all and equal without ending the occupation and establishing a viable and sustainable Palestinian state that possesses full competence and authorities like all member states of international community. The continuance of these violations means more Israeli escalations vis-à-vis the Palestinian people exercising their legitimate right to resist the occupation. Many decades have passed, and the suffering of the Palestinian, Syrian, and Lebanese peoples under the Israeli occupation continues, mainly due to the absence of a decisive and credible political will that is keen to implement the provisions of international law. Your Honours, today, and for all these reasons, and for the sake of genuine peace and unshakable justice, we look forward to the role of jurists who took it upon themselves to equally uphold the provisions of the law in order to contribute to achieving peace and justice to those people suffering under the most violent, most tyrannous, and most oppressive form of occupation in the history of humanity. Thank you, Mr. President. Thank you, distinguished members of the Court.
I thank the delegation of the Syrian Arab Republic for its presentation.
I invite the next participating delegation, that's Tunisia, to address the Court and call Professor Slim Lagmani to the podium. You have the floor, sir.
Monsieur le Président.
Mr. President, distinguished members of the Court, it is an honour for me to appear before your esteemed Court to set out Tunisia's point of view on the request for the advisory opinion before you. This is a request for an opinion which deals with the oldest and most unbearable injustice, namely that of the Palestinian people. In December 2022, Tunisia voted in favour of Resolution 77247 because it was then and remains now convinced that an impartial and lucid legal opinion given in response to the questions posed by the General Assembly is necessary not only for the General Assembly and the United Nations, but even more so for the international community as a whole. Regarding questions relative to the jurisdiction and discretion, we are of the opinion that those arguments which led the Court in its advisory opinion on the legal consequences of the building of a wall in occupied Palestinian territory to conclude, I quote you, not only has the Court jurisdiction to give an opinion on the question posed to it by the General Assembly, but there is no compelling reason for the Court to use its discretion to not do so. End of quotation. We are of the opinion that these arguments are valid for the instant request for opinion. There is, however, a specific argument in favour of the eminently legal character of the questions put in the instant request, and they're worthy of development. The reference by the General Assembly successively to occupation, to colonisation, annexation, shows that it is the law which is at the centre of the questions asked. Indeed, given the policies and practices of Israel in the OPT, we need to respond to the next question. Can we still speak only of an occupation, understood as placing a territory under the authority of an enemy army? Don't you think that really today this is a euphemism? Hasn't Israel gone far further than just merely annexing de jure or de facto the Palestinian territories by adopting laws and measures, discriminatory laws and measures, besieging Gaza since 2007 and conducting since 7 October 2023 a war of annihilation? Going further, in what legal category can Israel's illegal presence in Palestinian territory be placed? And like what some have claimed, the advisory opinion by the court answering this question would in no fashion be an obstacle to a negotiated political settlement of the Israeli-Palestinian conflict. Quite to the contrary, it's very useful to negotiations that negotiators be informed by an impartial third party on what they are legally entitled to demand and what they can or must renounce. But perhaps first we should look at what violations are in issue, and then we'll see subsequently what their legal consequences are. Mr. President, distinguished members of the Court, you have all the necessary elements establishing the continuing violation by violation of the right of the Palestinian people to self-determination, of the prohibition of aggression, the acquisition of territories by force, the serious and persistent violations of the human rights of Palestinians, and the intransgressible rules, that's your own words, of international humanitarian law. Amongst these elements, we shall refer specifically to those established by the decisions of the Security Council, which cannot be accused of bias against Israel, and by the court, whose independence, in your opinion of 9 July 2004, is beyond doubt. Those principles and rules breached figure in the non-existent list of peremptory norms of general international law annexed by the International Law Commission to their draft conclusions relative to the determination and legal consequences of just Kogan's norms. The Court, for its part, has characterized certain of the norms breached as just Kogan's rules, as, for example, the prohibition for the interdiction of prohibition of torture, crimes constituting serious breaches of the Geneva Conventions of 1949, and others have been qualified as erga omnes rights or obligations, of cardinal principles, of intransgressible principles, of principles, essential principles of contemporary international law, or indeed rules dictated by elementary considerations of humanity. Now, in the time frame that we have for this oral presentation, we can't look at all of these violations. It will suffice to show that the occupation of Palestinian territories, considered as a whole and in terms of duration, has as a final aim the negation of the Palestinian people's right to self-determination and the acquisition of its territory by force, and to attain this end, Israel has not hesitated to choose the most heinous of all means, namely the genocide of the Palestinian people. Let's look at the negation of the right of the Palestinian people to self-determination. At the end of the First World War, Palestine was placed under British Mandate A. Under Article 22, Paragraph 4 of the Covenant of the League of Nations, this mandate concerned, I quote, certain communities formerly belonging to the Ottoman Empire, which was the case of Palestine, These communities, as the article continues, have attained a level of development such that their existence as independent nations may be provisionally recognized. The League of Nations considered thus that Palestine was a nation, and that the mandate, when it expired, should have led to the definitive independence of Palestine, and this over the entire territory under the mandate. Now, throughout the mandate, the UK implemented the Balfour Declaration, part of the British mandate over Palestine. The declaration provided not for the creation of a Jewish state, but, I quote, for the establishment in Palestine of a national home for the Jews. This process led to Resolution 181, second session of the General Assembly of 29 November 1947, which recommended placing the city of Jerusalem under a special international regime, as well as a partition plan granting the Jewish state 56.47% of the mandatory Palestine territory. This recommendation, which ignored the raison d'etre of the mandate, which was to lead Palestine forwards towards definitive independence over the entirety of the mandated territory, had to be accepted by both parties to have legal effect. Now, the Jewish party accepted it, but the Palestinians and the Arab states of the region refused. The Jewish party, however, rushed to proclaim its state, and subsequently there was the 1948-1949 war, which led to a reduction of 23% of the space conceded to the Palestinian state by Resolution 1812, and to the exile of 750,000 Palestinians. Now, the effect of this war and the power balance which resulted were, at first, a step backward. The recognition of the existence of a Palestinian people and of its right to self-determination by the political organs of the United Nations was slow to come. With your permission. To start with, the Palestinians were considered as refugees, and we had to wait until 10 December 1969 for the General Assembly to recognise the inalienable rights of the people of Palestine. On 30 November 1970, the General Assembly will condemn governments, I quote, which refuse the right of self-determination to peoples to whom this right has been recognised, inter alia, the peoples of South Africa and of Palestine, and they will recognise the legitimacy of the struggle undertaken by those peoples subject to a foreign and colonial domination by all means at their disposal, and to obtain their recognised right to self-determination. End of quotation. The solemn recognition of the Palestinian people will come on 22 November 1974, where the General Assembly will assert the inalienable rights of the Palestinian people in Palestine, including A, the right to self-determination without external interference, and B, the right to independence and to sovereignty. The Security Council will be even slower to use the expression Palestinian people in its resolutions. It's in its Resolution 605 of 22 December 1987 that the Security Council will assert, as far as we know for the first time, the existence of a Palestinian people, where they say they deeply regret the policies and practices of Israel, the occupying power, which breaches the rights, human rights of the Palestinian people in occupied territories. In Resolution 672 of 12 October 1990, the Security Council will recognise the legitimate political rights of the Palestinian people. The Court will draw the consequences of this in its advisory opinion of 9 July 2004. The existence of a Palestinian people is no longer an issue. I quote you there. The recognition of the existence of a people carries with it the recognition of its right to the equality of rights, the creation of an independent and sovereign state, to the liberation and integrity of its territory. Now, clearly, the Palestinian people has been deprived by force from the enjoyment of all of those rights. That's what the court will conclude on 9 July 2004. I quote you. The obligation erga omnes to respect the right of the Palestinian people to self-determination is breached by Israel. But it wasn't only its right to self-determination that the Palestinian people has been deprived of. It has been deprived of its very existence. Mr. President, distinguished members of the court, the genocide is the crime of crimes, and very often this expression is used to signify it's the most serious of all international crimes. Now, we use it here to mean that once genocide is established, there is no need to establish the violation of the other rules and principles. We know that the court has been seized by this issue of genocide. But we have to look at it here as well. Why? Because genocide of the Palestinian people relates to the acquisition of Palestinian territory by force. Because the acquisition of Palestinian territory by force is the legal status of the occupation. The prohibition of genocide is incontrovertibly a jus cogens norm. The crime of genocide is defined by Article 2 of the Convention for the Prevention and Punishment of that crime. I quote, "For the purposes of the present statute, the crime of genocide is understood as being any of the following acts committed with the intention of destroying, in part or in whole, a national, ethnic, racial, or religious group. A. Killing members of the group. 2. Causing deliberate bodily or mental harm to members of the group. Small c. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, in whole or in part. And the imposing measures intended to prevent births within the group, and small e, forced transfer of children of the group to another group." Now, there is no doubt whatsoever that the Palestinian people is a national group within the meaning of Article 2 of the Convention. How could they not be, since they are a people, and they are thus entitled to the right of self-determination? There is no doubt either that those acts mentioned under paras A, B, C, and D have taken place and are taking place right now. The whole world has borne witness to this and is witness to it right now. The war against Gaza, the fifth since 2007, the systematic violation and massive violation of the fundamental human rights and norms of international humanitarian law, which the court has deemed intransgressible. In this respect, it's worth pointing out that genocide does not suppose the extermination of all members of the protected group. The court considered in its judgment of 26 February 2007 that, I quote you, "Genocidal intent must be to destroy at least a substantial part of the group in question," end of citation. And in this regard, the court found in its order of 26 January 2024 that, I quote, "The Palestinians of the Gaza Strip form a substantial part of the protected group." And in between times, the entire world has been witness of the land, maritime and aerial blockade of Gaza since 2007, the excessive use of force by the Israeli army and its security forces in occupied territories, leading to deaths and casualties amongst Palestinian civilians, including children and women and others. The acts of violence and harassment committed by groups of armed settlers towards civilians and children, destruction of property, homes, religious sites, historical sites, confiscation of land as collective punishment, expulsions, forced displacement of civilians, attempts to forcibly transfer Bedouin communities, detention of thousands of Palestinians, large number of women and children, elected representatives over an excessive period, without charge and without guarantee of due process, including ill treatment and sometimes even torture. There have been closing of certain areas, the placing of hundreds of obstacles to traffic, checkpoints, permit regimes impeding the freedom of movement of people and goods, inter alia medical and humanitarian, which is really important. But it's not enough just to establish this substantive element to prove genocide. The specificity of the crime of genocide resides in intent. Now, intent is always difficult to prove, but such proof is not impossible if you can establish the existence of a genocidal policy. That means an option taken collectively or individually by the authorities who have the power to decide and carry out this plan aimed at destroying the Palestinians as a national group. And such a policy exists. This is attested by Israeli legal texts, by the declaration of its politicians at the highest level, and by the systematic, coordinated character of its practices and measures. Let us recall the aggression of 1967, and since then the refusal to withdraw from occupied territories, which shows that Israel has occupied these territories to install themselves there definitively. The de jure annexation of Jerusalem, the de facto annexation of the West Bank by settlements which aim, in the long term, to establish a fait accompli. West Bank is no longer Palestinian. The basic law, my Syrian colleague referred to that. I quote here, Israel as the national state of the Jewish people, and in its first article defines the land of Israel as, I quote, the historic homeland of the Jewish people in which the state of Israel has been created. By thus referring with respect to this land, not to the international legality, but to a fable of identity, which includes all of mandated Palestine and more. The same article provides that the right to exercise national self-determination within the State of Israel is exclusively that of the Jewish people, giving thus a constitutional value to the very negation of the Palestinian people's right to self-determination. Let's also point out Article 7, which provides that the state considers the development of Jewish settlements as a national value and will act to encourage and promote their creation and reinforcement. Let us also recall the guiding principles of the coalition agreement of the current Israeli government, which was sworn in on 29 December 2022. The first of these principles expressly proclaims, I quote, that the Jewish people has an exclusive and unchallengeable right over all the areas, all the zones of the land of Israel, and engages the government to promote and develop settlements in all parts of the land of Israel, in Galilee, in Negev, in the Golan, in Judea, and in Samaria. End the citation. The 11th guiding principle asserts that the government will work to consolidate the status of Jerusalem. Let's also recall Israel's leaders' declarations, and we'll only cite two here just to give you a few examples. The first is that of Israel's Minister of Finance, dated 19 March 2023, last year. There are no Palestinians because there is not a Palestinian people. End of quotation. The second is the declaration of the Israeli Prime Minister. I quote him, "I will never compromise on the total control which Israel must maintain over security over all territory west of the River Jordan." All territory west of the River Jordan. End of citation. It is clear from these texts and declarations that Israel considers that all the territory of mandatory Palestine is its own, and that there is no Palestinian people. All of the foregoing shows, Mr. President, distinguished members of the Court, it shows the existence of a systematic policy, namely a clear intention and desire to destroy Palestinians as a national group entitled to self-determination and state independence, and to reduce the survivors to a group of stateless refugees.
Let's turn now to the legal consequences that stem from these violations. They may be classified into two categories: the particular consequence of the serious violations of peremptory norms of general international law on the one hand, and the specific consequences of the violation of the prohibition of genocide on the other. The International Law Commission has ascribed specific consequences to the serious violations of Jos Kogen's norms and has defined what it understood by serious violation is grave. A violation if it denotes on the part of the responsible state a flagrant or systematic breach to the execution of this obligation, end of quote. The violation of Jos Kogen's norms committed by Israel are both flagrant and systematic. Flagrant is used to refer to what is obvious for all to see. Is it not obvious to the eyes of all that Israel occupies the Palestinian territories, that it colonizes this territory, that is annexed Jerusalem, that in the war of aggression that it conducts against Gaza, it ignores and lays claim to the disregard it shows for principles of distinction and proportionality. It has deliberately targeted sites and protected persons. Systematic is used to refer to what is done with method and without failure, of what proceeds from a predetermined order beforehand, and what is deliberate. Is it not apparent from the policies and practices of Israel that there is a predetermined order, a plan hatched whose ultimate goal is to destroy the Palestinians as a people, to reduce them to dust as individuals, and that Israel has never ceased working to fulfill it? The results of the grave violations of peremptory norms of general international law, the following consequences: the responsible state cannot rely on circumstances excluding responsibility. Israel cannot assert neither self-defense, nor force majeure, nor distress, nor a state of necessity to exclude its responsibility, nor is it entitled to turn to countermeasures. As regards the other states, Jos Kogen's norms create erga omnes obligations, in respect of which all states have a legal interest. In particular, all states have a duty to cooperate to end, through lawful means, violations committed by Israel. All states have the duty to recognize as unlawful the situations created by the OPT and to refrain from all acts that might constitute aid or assistance in this regard. All states, and not just the aggrieved states, are entitled to invoke the responsibility of Israel. They can demand that Israel ceases these violations and assurances and guarantees of non-repetition, as well as discharging the obligation of reparation. The violation of the prohibition of genocide carries all the specific consequences of the violations of the Jos Kogan's norms. It also carries specific consequences provided for by the Convention for the Prevention and Punishment of the Crime of Genocide, and the Rome Statute of the ICC for all states that are parties to it. These specific consequences are as follows. Firstly, establishment of universal jurisdiction in this regard. State parties must notably provide for effective criminal sanctions aimed at persons guilty of genocide or any of the other acts incriminated by Article 3 of the 1948 Convention. Next, the right for any party to the 1948 Convention to seize the competent organs of the United Nations organization so that they take the appropriate measures for the prevention and punishment of acts of genocide. Thirdly, the right for any party to the 1948 Convention to seize the court through a unilateral request of any dispute pertaining to the responsibility of Israel in respect of genocide or any one of the other acts set out in Article 3, and that's what the state of South Africa did. Fourthly, the right for any state party or for any state that has accepted the jurisdiction of the ICC in accordance with Article 12, Paragraph 3 of the Rome Statute to seize the court if it has serious reasons to believe that a crime of genocide has been committed in its territory. That's what the state of Palestine did. Lastly, the right for any state party to the Rome Statute to defer to the prosecutor of the ICC the situation in Palestine and to ask him to investigate the situation. And that's what, on 17 November 2023, 5 state parties did: South Africa, Bangladesh, Bolivia, Comoros and Djibouti. We'll conclude our intervention by setting out the legal consequences that flow for the United Nations organization of the legal status of occupation as we have determined it. In this regard, we can but paraphrase the consequences highlighted by your court in its opinion 2004. The organization of the UN, specifically the GA and the UNSC, must examine what further measures might be taken to end the OPT and the serious and persistent violations of general peremptory law that are committed there. Mr. President, members of the court, I thank you for your attention.
I thank the delegation of Tunisia for its statement, which brings us an end to this afternoon's sitting. The court will meet again on Monday, 26 February at 10 a.m. to hear Turkey, Zambia, the League of Arab States, the Organization of Islamic Cooperation, and the African Union. The sitting is adjourned.
The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv.
Discover the Islam Channel podcast, where you'll find a perfect blend of inspiration, news, and business insights, all rooted in the beauty of our deen. Stay up to date with the latest trends. Engage in thought-provoking discussions. Subscribe to the Islam Channel podcast today. Discover the Islam Channel podcast, where you'll find a perfect blend of inspiration, news, and business insights, all rooted in the beauty of our deen. Stay up to date with the latest trends. Engage in thought-provoking discussions. Subscribe to the Islam Channel podcast today.